take a look at classifications of law. This is the chapter 3 for our syllabus. This chapter is quite easy. You just have to understand what certain laws means, and then you should be fine for this chapter. Okay, in this chapter, this is what is given in the syllabus. This is the subtopic given in the syllabus, but then I don't think it is actually ikut the urutan or even it is being classified properly. So I have made some changes. So this would be the checklist we would be using for our class today. Okay, the four major things you have to understand this topic is what is the difference between international law and domestic, or can be also called as the municipal or the national law. And second, in terms of the substantive law and the procedural law, and public law, private law, which is actually under the national law, and then criminal law and civil law. This has already been covered in chapter 1. So you're only going to talk about three new things in this chapter, and also plus with some other stuff like um adversarial system and inquisitorial system. Common law and civil law is also quite usual topic that is being discussed throughout the past two chapters. Okay, so this is just a okay. This is a summary that I created about the this chapter, but this is not the complete summary. This is just a draft or even the backbone of this chapter, but it can be developed further because, as you can see, here we do have international law, domestic law, substantive law, procedural law, public law, private law, but I did not cover criminal and civil. But that is usually under the civil justice system. This is a civil, this is the criminal. So um it is like 80% there, but you can still update the thing, with some other examples in terms of what is the international law, what is the domestic law. But I will be going through with you this first. Okay. So there's two major umbrellas under the system of laws, which is the international law and the domestic law. So it's very easy. International law basically means disputes between the nations, like Malaysia and probably Thailand. We have certain issues that would be covered under the international law. And then second is the domestic law, the national law, which is like the laws that apply within a country. For example, road law, or some kind of law during the PKP. All of that, it really applies only in the country, and once you move out from the country, you do not have to abide by the law. That is domestic law. Okay, under the domestic law, we have two different kind of umbrellas, which is substantive law and procedural law. Okay, this might sound a bit complicated, but it's not. Believe me, it is like incredibly easy to understand. Okay, substantive law basically means, for example, you have something called criminal law or family law, tort law. All of these laws, which is written in words, and you learn about what is the law. All of that is substantive law. It's basically the actual rules and regulation that dictate what we can do and we can't do. Okay. Then now you have to understand what is the procedural law. Procedural law basically, for example, let's say you have a criminal law where if you kill somebody, you will be prosecuted, for example. And in order for the law to be conducted, you would be going through something called the criminal proceeding. So the criminal proceeding is basically the procedural law, because as you can see, the root word for procedural is procedure. What is the cara? Apakah langkah? All of these kind of things will go under the procedural law, because you can say, okay, this person is wrong according to this law. But if he's wrong, what is the next step for you to enforce the law, enforce the rules on to him? And in order to enforce the law, you need the procedural law. You have to go to trial. You will go through, certain procedures in the court, outside the court, etc. Okay. So that is a substantive law and procedural law. So the procedural law, we won't be covering much in the syllabus. Another thing you have to know is what is under the substantive law. Under substantive law, which is substance. You know what is substance? It's basically the background of it, the written element of it, the substance of the law. For example, criminal law, or tort law, or even family law. So under the substantive law, we have two different kind of law, which is the public law and the private law. Public law, basically, you can see it is clearly written as public, so it is completely what it says. It involves state and government in some way. For example, if the public has caused some kind of interruption or some kind of wrongdoing in a certain element, they would have to face the government or the state For example, it's a criminal law. For example, if you kill somebody, you have to face the court. You have to go through some certain kind of procedures in order to be convicted, or in order to prove that you're not guilty, for example. And private law basically means that it's just the law between two different individuals. So this is much more smaller in some aspect, because this involves the government and this doesn't involve the government. That is the difference. That is the major difference in both of these law. Public law involves government, private law doesn't involve the government. It is just between two individuals. While this is government versus some individual. The government is usually the public prosecutor, or in the UK, it will be the Regina. It really depends in which country you're in. So in public law, there are only three basically, only three umbrellas under the public law, which is the criminal law, which is under the criminal justice system. Constitutional law, is anything that refers to our constitution, perlembagaan persekutuan. And then administrative law is basically the body of law that governs the activities of administrative agency of the government. For example, let's say Kementerian Pendidikan, they have certain laws, or even Kementerian Pengangkutan, or whatever, government or the ministries would be governed under the administrative law and how they should administrate certain things. And that will be the public law, because it really depends on the government and even the state in some way. And next is the private law. Private law basically is me and you. For example, I have some issue with you. It's just two of us. There's nobody, none of the government will be involved in this. So examples of private law, I'm just gonna highlight a few that is easy for you to remember. There's three different sections: law of obligations, law of property, and others basically is like all the other law which doesn't really have like a proper umbrella. Okay, the popular laws you can remember for law of obligations: contract and tort. Trust and unjust enrichment, sure, you can go ahead and try to really understand on it, but I won't be covering here because it's not really emphasized on the syllabus. Okay, I know they have already covered what is contract law and tort law. If you do not know what is contract law or tort law, please look at my chapter 2 and chapter 1 videos, because it's already there. Okay, the law of property, land law, personal property, intellectual property. Intellectual property is basically, for example, you are stealing somebody's ideas, stealing somebody's music, stealing somebody's innovation, and we go under the intellectual property law. And then for others, like you can remember family law, law of succession. Law of succession basically means like, for example, your grandfather died, and then the harata, will go to the grandson or whatever, that is the law of succession. Consumer law, employment law, company law, partnership law. Okay, I think partnership is not that popular, so you can just remember family law, employment, and company should be good to go for this chapter. But most of it is like some extra information for you, so you don't really have to know exactly what does it mean. But I'm just giving it for you, just a quick I would say more like amaran lah, because all these things you have to probably know if you're going to take law. Okay, and then we are moving into the first checklist, which is the common law and civil law. Okay, why do I have this? Basically, the legal system we face now, whether it's in Malaysia or it's in some European country or in America or in Australia, most of the legal system are basically derived from these two things, which is this common law and the civil law. So I'm pretty sure common law is something that I already covered in chapter 1 and chapter 2. And also you will also learn it in chapter 4 about common law and equity. So that will go under the common law, which is basically the law during the Norman conquest, and there was the basic law in the UK, which was derived into the Commonwealth country and etc. Civil law, of course, I already covered this in chapter 1. Civil law is what protects the basic right of the individuals. Contract law, tort law, everything goes under the civil law. So you can also see here, civil justice system. All of this goes under the civil law. Only the criminal law goes under the criminal justice system, which is the criminal law. Okay, so first we're going to take a look at what is the difference between civil law and common law. This is basically a very quick revision before we move into the chapters. Okay, so as I already said, some of the sources of the legal system is the common law and the civil law. So common law, the origin of it was the English law, which was created in the UK, and it was basically being interpreted in many other Commonwealth countries, as well as in like Europe, Japan, or Latin America. And civil law is the law of Rome. And this law has been focused in some of the countries like Malaysia, like us, or some English colonies. And the main difference between civil law and the common law is that civil law focuses more on the rights of the individual, but common law focuses on the remedies. Why the common law focuses on the remedies? Because if you take a look at chapter 4, common law has something called equity. During the Norman conquest, there were some issues with the common law because common law was, sourced from many different kind of informal elements such as religion or religious doctrine or even like societal principles. So the common law had its own inadequacies. For example, like the remedies were not enough because most of the remedies were monetary compensation. You have to like bias certain things in order to solve your legal disputes. So but this thing wasn't really affordable for every single person because not everybody could afford the monetary compensation. So because of that, common law was considered as something that was not entirely full and complete. So there was something called equity, which was created by the Court of Chancery, because the court for common law is Curia Regis, and the court for equity is Court of Chancery. So you have two different courts you have to consider. So because there were a lot of inadequacies for the common law, equity was created in the Court of Chancery. So initially, they did have two single and individualistic courts. One court of Curia Regis, one at the Court of Chancery. So both of this is that the common law court provided less remedies compared to the Court of Chancery. So it was considered as more inflexible, expensive, and very rigid, incredibly rigid and strict. So in the Court of Chancery, they focus more on the remedies. Remedies basically what you can do to solve a legal dispute. Maybe you pay some money, or you have injunction, rescission, all that kind of stuff. That goes under the Court of Chancery. So what happened is that I think in 1928 or 15, I can't remember exactly the date. I think 18 or something. You should check it out. The Judicature Act was created um, in order to unify the court of common law and the court of equity, because I say they were two different singular courts which were standing alone. So they kind of like combined both of that through the Judicature Act in order to provide a complete court that can actually rule the United Kingdom. So that's why in common law they focus more on the remedies. Okay. And the judicial president, okay, you might ask, what is a judicial president? This is actually like one chapter that you would study in terms of the judiciary, which is the judges and etc. So this is a term that you have to understand. It's very easy term. Judicial president basically refers to where the court makes the decision based on ruling on similar cases. For example, you have a case, that is like that's happening right now. The case in terms of somebody killed somebody else, for example, and there was a similar case in the past where this person A killed the person B. And of course, and during that case, the punishment was that he had, for example, hukuman gantung or something. And if you're facing a similar case in the future, the punishment has to be equally same as the past case. Because that is when there is a term of justice and fair in terms of the case as well. And that's what basically refers to the judicial president, where the lower court would refer to the higher court decision in certain cases, or like in order to ensure there is equal amount of equity in all of the cases. Because of course you can still come up with like totally new decisions, totally new cases, because you have certain tools in order to like break the judicial president, which is also can be referred to as the doctrine of president. This is what is the judicial president is like a term. Doctrine of president is basically the law which says the lower court has to refer to the higher court's decision. That's it. Okay, and then common law, they talk more on the code of written law, because in the common law, they focus more on the written law. So, for example, as I said, in the common law, we had equity and etc. All of this was the written law in the past. So, they really focus more on the code of the written law, which typically refers to a comprehensive and systematic compilation of laws or even statutes that have been codified or organized into a single document or a set of documents. For example, you can talk about civil code, the criminal code. For example, you have made some criminal offense. What would be the penalties, or what would be the remedies that you have to face in order to solve your criminal behavior, something like that. Okay. And the mode of court procedure, which is why we have to understand this in order to go to this, we have two different systems in terms of the systems of the court itself, which is the adversarial system and inquisitorial system. So in the civil law, we focus more on the adversarial system, which is also a system used in Malaysia. This is where the rule of the court is primarily that of an impartial referee between the prosecution and the defense. So what does it mean? Basically, it means that whatever you see in your movies, you have a lawyer who is speaking for the victim, or for somebody who's pleaded guilty. So basically, that is what it means by the adversarial system. In inquisitorial system, the court or part of the court is actively involved in investigating the case fact. So what does it mean? This means that the judges have the responsibility to interfere and start the investigation. Okay, you would understand more on this once we take a look at second one. Okay, so just to recap again, civil law and common law is basically the sources of the legal system which build the entire legal system that you see today. That's it. But there's like some extra information on how you can explain common law and civil law when it comes to your essay question. So we are done with the first one. Next, we're going to take a look at the adversarial system and inquisitorial system. Okay. I hope you're clear on the first one. So we're going to take a look at the second one, adversarial system and the inquisitorial system. Okay. So the main difference is that in adversarial system, the lawyers are in control, while in the inquisitorial system, the judge is in control. So the difference basically means that in the adversarial system, it is so much better for the defendant to be involved in the system, and for inquisitorial system, it's for the society. Why? Because in adversarial system, it's more sensitive to the liberty of the citizen, because the lawyer is fighting for the victim, so they are not being convicted in certain law. But in inquisitory system, there's more emphasis on ensuring the punishment of a guilty party. They focus more on the punishment, because lawyers, they don't really argue much. They're just gonna let the judge to be in the authority. So yeah, I have given you like 15 different kind of differences. I'm going to go through few of it with you, which are the important ones you can remember. Okay, in adversarial system, you have to focus more on the rules of the evidence, while in inquisitory system, they don't really focus much on the evidence. Okay, in adversarial system, the judge plays an umpire. Basically, it means that the judge have least amount of role, or just like a referee, you can say. But in inquisitorial system, the judge acts as a director. They are the main person who is investigating the entire situation. Okay, the objective for adversarial system is to arrive at the possible truth, which might be, like when you look at like certain um court procedures, sometimes they don't really achieve the truth. They just achieve a certain truth that is logical. But then in inquisitorial truth, they want the absolute truth, the A to Z of apa yang terjadi, comparing to like the adversarial system. Okay. And number four, the judge. This refers to this. The judge have very little involvement. Here, the judge actively involved because they are the director. No possibility of bias. There is a possibility of bias because over here, the both things being handled by two different lawyers. So two different lawyers are fighting, arguing, to prove who is right or who is wrong. But in here, only one judge is available. So the judge can be biased to like certain party. That's what they mean by possibility of bias. Okay, less time consuming, more time consuming, because this might take a lot of trials, because one judge is gonna, focus on many different kind of cases at the same time, and there's gonna be myriad of trial going on to for a very long time. Less expensive, more expensive. Okay, this all should be quite easy to understand. Okay, I think yeah. Investigation will be with the police, investigation will be judicial. Judicial basically refers to the judge. Because when it comes to a criminal case, you know that the person who has to start the case is the police, not the victim or even who's being accused. The person who starts the case is the police itself. That's why they're saying that in adversarial system, the investigation will be with the police. Okay, I think all of the other things that can be read by you guys because it's quite easy to understand. I've chosen the most language for this part, so you can just read through all of this. Anything else that I did not cover? Okay, yep. This is the summary for the entire thing that you could remember in your examination. This is just for your understanding purposes, so you can just read through. Okay, before we move into the next one, I want to show you guys a video. Okay, give me a moment. I'm gonna open the YouTube channel. Okay, let's see. Yep.